1. I note that a quorum is present. The subcommittee is meeting today for a hearing to hear testimony on the basis of sex, examining the administration's attacks on gender-based protections. As this is a completely virtual hearing, I ask that all microphones for members and witnesses participating remotely be kept muted as a general rule to avoid unnecessary background noise. Members and witnesses will be responsible for unmuting themselves when they are recognized to speak or when they wish to seek recognition. Further, pursuant to House Resolution 965 and its accompanying regulations, members are required to leave their cameras on for the entire time they are in an official proceeding, even if they step away from the camera. This is an entirely remote hearing, and as such, the committee's hearing room is officially closed. Members who choose to sit with their individual devices in the hearing room must wear headphones to avoid feedback, echoes, and distortion resulting from more than one person on the software platform sitting in the same room, as has been reported by other committees. They are also expected to adhere to social distancing and safe healthcare guidelines, including the use of masks, gloves, and wiping down their areas, both before and after their presence in the hearing room. Although a roll call is not necessary to establish a quorum in official proceedings conducted remotely, whenever there is an official proceeding with remote participation, the clerk will call the roll to help make clear who is present at the start of the proceeding. So at this time, I ask the clerk to call the roll.
Ms. Bonamici?
Present.
Mr. Grijalva? Ms. Fudge? Ms. Schreier? Mrs. Hayes?
Present.
Mr. Trone? Mrs. Lee?
Present.
Chairman Scott?
Present.
Mr. Klein?
Present.
Mr. Thompson? Ms. Stefanik? Mr. Johnson?
Present. Thank you.
Mrs. Fox? Chairwoman Bonamici, this concludes the roll call.
Thank you so much, and I do want to welcome.
I'm not sure you heard me because I think I was muted. This is Virginia Fox.
You are present. Thank you.
And I want to welcome Mr. Klein to the subcommittee in his first hearing as ranking member. So opening statements pursuant to Committee Rule 7C, opening statements are limited to the chair and ranking member. This will allow us to hear from our witnesses sooner and provides all members with adequate time to ask questions. So I recognize myself now for the purpose of making an opening statement. In the last 4 years, the Trump administration has taken many actions that erode civil rights protections for women and LGBTQ individuals. Today, we will discuss the effects of these actions on our schools, workplaces, and healthcare system. One of the administration's most recent and well-known attacks on gender-based civil rights is its changes to the rule implementing Title IX. Under Title IX of the Educational Amendments of 1972, schools have a responsibility to provide equal access to education for all students. As part of Title IX's requirements, schools receiving federal funding, including institutions of higher education and K-12 schools, must take certain steps to address sexual misconduct that inhibits student safety or access to education. Title IX is a necessary tool for protecting students' rights at a time when 1 in 5 women experience sexual assault during college. Yet in May, Secretary Devos finalized a harmful rewrite of the Title IX rule. Problems with the Devos Title IX rule include but are not limited to the following. The Devos rule makes it harder for sexual assault survivors to receive justice by increasing the burden of proof beyond what other civil rights laws require, and forcing survivors to endure live cross-examination. These changes are likely to discourage survivors from reporting instances of sexual harassment and assault, which are already severely underreported. Another part of the rule gives colleges a pass if an incident is reported to the wrong person. and it significantly narrows the definition of sexual assault to one that will excuse large swaths of sexual misconduct under Title IX. Furthermore, only schools found to be deliberately indifferent to complaints will be considered in violation of Title IX. This rule is simply too burdensome for survivors, and it fails to hold institutions accountable for protecting students. There is no appropriate time for the federal government to erect barriers to justice for survivors of sexual assault, but the administration's decision to finalize this rule in the middle of the COVID-19 pandemic was a stunning display of callousness. I also want to express my profound opposition to the Education Department's refusal to halt its efforts to restrict the rights of transgender students. In Bostock versus Clayton County, the Supreme Court recently held that prohibitions against discrimination on the basis of sex prohibit discrimination against LGBTQ individuals. Although the decision was under Title VII because it was in the context of employment, Title IX was essentially modeled on Title VII. There is no rational reason why on the basis of sex should be interpreted differently. In fact, the Supreme Court in Bostock held that it is impossible to discriminate against a person for being gay or transgender without discriminating against that individual based on sex. Despite that clear language, the department continues to ignore the holding in that case from the United States Supreme Court. As we speak, the Trump administration is also threatening to strip funding from Connecticut schools that allow transgender athletes to compete according to their gender identity. This threat is cruel and harmful. As cash-strapped schools face unprecedented challenges related to COVID-19, the department is using federal funding to coerce these schools into harming transgender students. We must condemn this behavior in the strongest possible terms, and the department should immediately rescind its efforts aimed at signaling out and humiliating transgender students. The Trump administration's record on removing civil rights protections against gender bias in the workplace is equally as offensive. During the president's first year in office, he turned his back on LGBTQ workers by systemically erasing workforce protections. In October of 2017, the administration reversed an Obama-era policy that clarified transgender workers are protected from discrimination under Title VII of the Civil Rights Act. The very next day, the Department of Justice issued sweeping guidance that gave federal agencies license to discriminate against LGBTQ workers in a memo that stated that the DOJ would take the position that Title VII's prohibition on sex discrimination does not include gender identity, including transgender status. In response, the House passed the Equality Act, the historic proposal to secure LGBTQ rights and to prohibit discrimination. As I mentioned, the Supreme Court's decision in Bostock made clear that federal civil rights protections on the basis of sex covers sexual orientation and gender identity. But that decision does contain some potential loopholes that could be used in an attempt to justify discrimination. So it's an important but incomplete step toward providing LGBTQ workers the workplace protections they deserve. That's why we need the Equality Act. Another concern is the administration's efforts to eliminate the collection of pay data by the Equal Employment Opportunity Commission. This was an effort to obscure gender-based pay discrimination as well as race discrimination and provide cover to employers that fail to provide equal pay for equal work. The decision to end the collection of pay data is an unprecedented setback for the enforcement of Title VII, Executive Order 11246, and the Equal Pay Act. Another serious consequence of the Trump administration's gender-based attacks is in the area of healthcare. As we continue to confront the COVID-19 pandemic, the administration continues to restrict access to healthcare. Specifically, the administration has tried to roll back an Obama-era rule that strengthened the anti-discrimination provisions in the Affordable Care Act, known as Section 1557. Section 1557 is designed to prohibit discrimination against patients on the basis of race, color, national origin, sex, age, or disability. On June 19th, at a time when our nation eclipsed more than 2 million confirmed COVID-19 cases and there had been more than 114,000 confirmed and probable deaths, a number that has sadly risen since June, the administration removed the explicit provisions that protected against discrimination based on pregnancy and pregnancy termination and instead restored an outdated interpretation of sex discrimination that excludes gender identity. In other words, a rule that was meant to guarantee proper care for women and LGBTQ people was contorted in a way that means they can be denied care in the middle of a global pandemic. Although the rollback of Section 1557 was put on hold by a federal court, it still looms as a threat to the health and well-being of millions of Americans. We are in challenging times. Millions of Americans have lost their jobs, their health insurance, and thousands have lost their lives. This nation deserves better. I thank our distinguished witnesses for being here today, and I look forward to the discussion. And now yield to Mr. Klein for an opening statement.
Thank you, Madam Chair. I appreciate the opportunity to serve with you on the subcommittee, and I'm looking forward to continuing the great work that this subcommittee has done in previous efforts. Prior to coming to Congress, I was proud to serve as a prosecutor locally of domestic violence cases to ensure that justice was done. Additionally, during my time as a delegate in the Virginia State House, I authored several bills to increase protections for such victims and their families. And since I arrived in Congress, I've worked across the aisle to introduce legislation alongside Congresswoman McBath to allow funds allotted through the Family Violence Prevention Services Act to still be accessed by removing certain requirements during the pandemic. Here in Congress, this committee has created protections for pregnant women, students, and workers alike so they can live, work, and learn in environments free from violence and discrimination. I know I speak for all my colleagues here today when I say no one should ever be denied an opportunity because of unlawful discrimination. That's why my Republican colleagues and I consistently support legislation that aligns with protections defined under existing civil rights laws. These very laws are what ensure the fairness I mentioned earlier in classrooms and workplaces across the country. Unfortunately, the same cannot be said for my colleagues on the other side of the aisle. The majority will often cherry pick who does and does not deserve protections. Democrats have undermined students' rights and fundamental fairness under Title IX of the Education Amendments of 1972. In 2011, the Obama administration issued guidance that created significant controversy and confusion. Many criticized the guidance for undermining due process rights for involved parties and for denying public review and comment from affected stakeholders. In fact, multiple court cases have struck down campus procedures that resulted from the guidance. The Trump administration addressed this past wrongdoing by taking over 124,000 public comments into consideration while drafting a rule that defines the responsibilities of institutions to respond to allegations of sexual harassment, including sexual assault, under Title IX. Some have been critical of the Education Department's updated Title IX rule, despite the fact that the rule is rooted in our deepest, time-tested legal traditions. It requires schools to take all allegations of sexual harassment, including sexual assault, seriously, and support and protect survivors during every step of the process. This rule will help ensure that all students can pursue education free from discrimination, harassment, and sexual violence, and we owe it to survivors to ensure that clear and fair procedures are in place to respond to sexual violence. The Department of Education's Title IX rule delivers on this front. The majority has also consistently tried to roll back protections that allow religious organizations to operate in accordance with their sincerely held religious beliefs. In fact, they slammed a proposed rule announced last year by the Department of Labor to protect religious liberty. Religious organizations have been discouraged from seeking federal contracts because of uncertainty surrounding the requirements for religious organizations. The Department of Labor's proposed rule clarifies the protections given to religious organizations that contract with the federal government. DOL rightly considered recent Supreme Court decisions regarding the religious freedom of employers, which affirmed the limitations on the government to infringe on the free exercise of religion. Not only does this proposed rule protect religious liberty, it also benefits both the contracting system and taxpayers by encouraging additionally qualified organizations to bid for contracts, which will increase competition and provide needed goods and services that may otherwise not be available. The bottom line is all Americans deserve to learn and work in an environment free from discrimination based on their sex or religion. Committee Republicans have and will continue to advocate for policies that allow students to learn and employees to work in environments free from discrimination. While I look forward to the testimony from our witnesses today, I'd like to point out that the majority only allowed the minority to invite one witness to cover a very broad set of issues. Unfortunately, this structure will limit the subcommittee's ability to have a robust discussion today on how to best ensure Americans can pursue an education and a career in positive environments. Thank you, Madam Chair, and I yield back.
Thank you, Ranking Member Klein. All other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on Thursday, August 24th. I will now introduce our witnesses. Jocelyn Fry is a senior fellow at the Center for American Progress, where she focuses on a wide range of women's economic security and employment issues. Prior to joining the center, Fry served for 4 years as Deputy Assistant to President Obama and Director of Policy and Special Projects for First Lady Obama, overseeing the broad issue portfolio of the First Lady. Next, Sasha Booker is a senior attorney in the Washington, D.C. office of Lambda Legal, the oldest and largest organization dedicated to advancing the civil rights of lesbians, gay men, bisexuals, transgender people, and people living with HIV. Before joining Lambda Legal, Sasha served as staff attorney and policy counsel at the Transgender Law Center. Sasha was the first openly transgender person to be appointed to an Oregon State board, and from 2012 to 2013, she served as chair of the Oregon State Hospital Advisory Board. I welcome an Oregonian to the panel. Next, Samantha Harris is a senior fellow at the Foundation for Individual Rights and Education, FIRE, an advocacy group defending and sustaining the individual rights of students and faculty members at America's colleges and universities. Ms. Harris has held several positions at FIRE, including Vice President for Procedural Advocacy and Director of Policy Research. Additionally, Ms. Harris serves as counsel at the law firm Mudrick & Zucker, representing students and faculty members. And finally, Fatima Graves is President and CEO of the National Women's Law Center. She is among the co-founders of the Time's Up Legal Defense Fund, which connects those who experience sexual misconduct in the workplace with legal and public relations assistance. She's held many positions at NWLC, including Senior Vice President for Program and Vice President for Education and Employment. She led the center's anti-discrimination initiatives with a particular focus on outcomes for women and girls of color. Instructions to our witnesses: we appreciate the witnesses for participating today, and we would look forward to your testimony. I remind the witnesses that we have read your written statements, and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. I also remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress, or otherwise conceal or cover up a material fact. During your testimony, staff will be keeping track of time and will use a chime to signal when 1 minute is left and when time is up entirely. They will sound a short chime when there is 1 minute left and a longer chime when time is up. Please be attentive to the time and wrap up when your time is over and remute your system. For the witnesses participating remotely, if you experience technical difficulties during your testimony or later in the hearing, you should stay connected on the platform. Make sure you are muted with the mute button highlighted in red and use your phone to immediately call the committee's IT director, Sheila Havener, whose number has been provided. We will let all witnesses make their presentations before we move to member questions. When answering a question, please remember to unmute your system. I will first recognize Ms. Fry for 5 minutes.
Thank you, Madam Chair Bonamici, and Ranking Member Klein, members of the subcommittee. Also, I want to acknowledge Chairman Scott and Ranking Member Fox. Thank you for the invitation to be here. It's a true privilege. My name is Jocelyn Fry. I'm a senior fellow at the Center for American Progress. The center is a think tank devoted to progressive values and improving the lives of all Americans. And I work with our women's initiative that has focused on expanding employment and economic opportunities for women, because we believe that women are integral to the economic progress of our nation now and in the future. As you well know, this hearing occurs at a critical moment, both in terms of the economic crisis that we are dealing with because of the global pandemic, but also because we are engaged in a robust and important conversation about the presence of systemic racism and other forms of bias. And I think both of those conversations are relevant today. because it's critical to create equitable workplaces and to really challenge systemic practices that for years have depressed the wages and opportunities for women. And it's precisely because of the urgency of those issues that we have opposed some of the actions of the Trump administration, specifically that undermine workplace enforcement and key protections that women often depend on. I'm going to just highlight a few of those actions, and then I'm happy to respond to questions. On equal pay, as the chair alluded to, one of the actions that has been most troubling is the administration's decision to discontinue the collection of pay data. The collection of pay data is critical to enforcement, and the rule that was adopted during the Obama administration was really an effort to close a gap in the information that was available to enforcement agencies. And the decision of this administration to decline to continue that will impact the ability to ensure progressive and robust enforcement going forward. I also want to call attention to the rescission of the Fair Pay and Safe Workplaces executive order. There are a couple of provisions that are particularly relevant to our conversation. One on pay transparency that would have given employees better information about their pay to ensure they're being paid fairly. There's also provision dealing with arbitration and preventing the use of pre-dispute arbitration provisions that can curb the ability of workers to bring discrimination claims and sexual harassment and assault claims. Both of those provisions, with the loss of those, are problematic. I also want to draw attention to the issue of just the wholesale curb of protections for LGBTQI plus workers, in addition to the reinterpretation of Title VII to exclude workers who are transgender and to limit the ability to bring cases based on gender identity. The administration has also sought to undermine protections in federal contracting, using religious freedom as an excuse to permit discrimination. And while we certainly respect the right of religious freedom, we also don't think that that should be used as an excuse for discrimination, and it's a misuse of the executive order power. There are other measures that I will be happy to discuss. I do want to draw attention to some newer things that we are seeing, including there's a new rule that we've seen from the EEOC that may make it easier for employers to effectively delay litigation by trying to just inject repeated requests for conciliation. Obviously, we want employers and the commission to be able to engage in conciliation, but we don't want it to be used as a tool to delay the ability of the commission to move forward when needed. I also would be remiss if I didn't mention things that they could be doing. In addition to reinstating the pay data disclosure, we should be thinking about new measures. The UK does pay data disclosure where they require employers to publish their wage gap. We should be thinking about ways to challenge things like intersectional discrimination and the experiences faced by women of color. I think at the end of the day, what is most important is to have robust enforcement of the law that gives us confidence that this administration is committed to equal employment opportunity. Thank you.
Thank you for your testimony. Next, we will hear from Ms. Booker for 5 minutes.
Good afternoon, Chairwoman Bonamici, Ranking Member Klein, and distinguished members of the committee. Thank you for the opportunity to testify during this important hearing. My name is Sasha Booker, and I'm a senior attorney at Lambda Legal. And I'm also a daughter, a sister, a Marine Corps veteran, and a proud transgender woman. This hearing follows 3.5 years of relentless attacks by the Trump-Pence administration targeting LGBTQ people in a wide range of contexts, including, to name just a few examples, the ban on open transgender military service, attacks targeting transgender students, LGBTQ workers, immigrants, prisoners, elders, transgender homeless people, and as this testimony will identify, LGBTQ patients. And no federal agency has targeted LGBTQ people more than the U.S. Department of Health and Human Services. the agency tasked with enhancing the health and well-being of all Americans. Lambda Legal has now filed 6 different lawsuits against HHS in the last 3.5 years to block administrative changes that invite harm to our community. One of the most pernicious attacks from HHS came less than three months ago, well into the pandemic, when HHS chose to finalize a rule seeking to carve out clarification that LGBTQ people, women, and other vulnerable communities are protected under the non-discrimination provisions of Section 1557 of the Affordable Care Act. HHS announced the final rule on Friday, June 12th, and the following Monday, the Supreme Court issued the Bostock decision, in which Justice Gorsuch clarified in a 6-3 majority opinion that it is impossible to discriminate against a person for being gay or transgender without discriminating on the basis of sex. In response to this very clear Supreme Court precedent concerning a statute that is read consistently with Title IX, members of the community and policymakers quickly informed HHS that the proposed rule conflicts with this decision and urged them to withdraw the rule. But HHS would not be deterred. Less than 5 days later, after the Bostock decision was issued, HHS barreled forward and published the final rule on the following Friday without a single mention of the Bostock ruling. HHS's refusal to address the Bostock decision is breathtaking and manifests a stunning disregard for the rule of law and reveals the agency's single-minded pursuit to strip life-saving protections from LGBTQ people and other vulnerable communities. Unsurprisingly, the rule has already been enjoined by 2 different federal courts for this very reason. In another example of HHS's repudiation of its purpose and mission, HHS issued the grants rule on November 19, 2019, which seeks to eliminate express non-discrimination protections for people seeking HHS programs and services. HHS grants $525 billion a year to millions of people in a wide array of programming that includes HIV prevention programs, programs servicing older Americans like Meals on Wheels, programs serving youth experiencing homeless, and early childhood programs like Head Start. The rule, if finalized in force, would have a devastating impact on LGBTQ people, but especially it would have a devastating impact on youth. There are more than 125,000 youth who cannot safely return to their families of origin, waiting to be adopted into stable and loving homes. And it's reprehensible that HHS is seeking to allow agencies to turn away competent and loving foster and adoptive parents and jeopardizing that opportunity for placement, for permanency and placement. And yet one more example of HHS turning its mission on its head is HHS issued a final rule in May of 2019 that, among other things, improperly sought to expand statutory religious exemptions to greatly expand the number of people who could claim it and the kinds of health cares that can be denied, essentially inviting healthcare providers to deny LGBTQ people healthcare treatment. The justification for that rule is they had supposedly received a significant number of complaints from religiously affiliated healthcare providers over a 2-year period. They said they had received 358, but in the course of litigation, it came to light that almost 80% of those were vaccination-related complaints, which HHS concedes were duplicates. In closing, I would just say that although these attacks continue to be struck down by the federal courts, they don't come without a cost. The rules place healthcare providers in legal jeopardy by falsely telling them that it's fine to discriminate. But more concerning, the rulemaking fosters discrimination against LGBTQ patients and discourages people from seeking healthcare in the first place. And the rule would, of course, fall hardest on those already marginalized communities, including people of color, people living with low incomes, women, and LGBTQ people. Thank you so much for the opportunity to testify, and I look forward to your questions.
Thank you for your testimony, and I now recognize Ms. Harris for 5 minutes.
Chairwoman Bonamici, Ranking Member Klein, and distinguished members of the subcommittee, thank you for allowing me the opportunity to testify here today. The new Title IX regulations are not an attack on gender-based protections. Rather, they restore Title IX's original focus on a complainant's access to education. They realign with decades of regulatory and judicial decision-making about Title IX, and they clarify and standardize disciplinary procedures following numerous court decisions about what Title IX and Due Process Clause require of colleges and universities in these cases. In all of these regards, the new regulations are a sorely needed correction to a system that had strayed very far from its original purpose. The focus on access to education is evident in the regulations requirement that colleges and universities offer supportive measures to all complainants, whether or not they file a formal complaint. The regulations also return control to complainants in other important ways, such as by allowing for informal resolution when both parties prefer that route, and by ensuring that medical records cannot be used without a party's consent. The regulations also restore a definition of harassment and a jurisdictional scope that were established by the Supreme Court in Davis v. Monroe County Board of Education. After Davis was decided in 1999, the Clinton administration's OCR issued guidance in 2001 explicitly stating that although Davis concerned the liability context, quote, the definition of hostile environment harassment, sexual harassment, used by the court in Davis is consistent with the definition, unquote, used by the Department for Administrative Enforcement. OCR further stated that, quote, schools benefit from consistency and simplicity in understanding what is sexual harassment for which the school must take responsive action. A multiplicity of definitions would not serve this purpose. The department departed radically from this in the years between 2011 and 2017, when it instructed schools to define sexual harassment far more broadly and at public institutions unconstitutionally as, quote, any unwelcome conduct of a sexual nature. The 2001 guidance did use the phrase unwelcome conduct of a sexual nature to generally describe sexual harassment, but it was not, as some argue, the operative definition in that guidance. Rather, the department adopted an operative definition that it asserted was consistent with the one set forth in Davis. Similarly, the jurisdictional limitations imposed by the regulations come directly from the Supreme Court's decision in Davis, where the court stated that, quote, the language of Title IX, which again addresses only discrimination that occurs under an education program or activity, cabins the range of misconduct that the statute prescribes. The court wrote that the statute's plain language confines the scope of prohibited conduct based on the recipient's degree of control over the harasser and the environment in which the harassment occurs. The Supreme Court has defined the jurisdictional limits of Title IX. It is not within the authority of an agency to ignore those limitations. Finally, the regulations establish uniform, fair procedures for institutions to use in adjudicating sexual misconduct complaints. In response to the hundreds of lawsuits from respondents who allege they were denied a fair process, there has emerged a patchwork of case law surrounding Title IX, such that one's rights in a Title IX proceeding depend on where one lives and attends college. It fell to the Department of Education, therefore, to standardize the rights of students under what is, after all, a federal civil rights statute. This is the agency's proper role and statutory charge. Moreover, the department is obligated to ensure that students' constitutional rights, including First Amendment and due process rights, are not violated in the implementation of Title IX, and that has been a rampant problem over the past 10 years. The procedural safeguards in the new regulations, live hearing, cross-examination, meaningful notice and access to evidence, and the presumption of innocence are all things that various courts have held are part of students' due process rights. Now these essential provisions will protect all students. Thank you very much for your time, and I look forward to answering your questions.
Thank you for your testimony, and I now recognize Ms. Goss-Graves for 5 minutes. And you need to unmute yourself.
Apologies. Thank you, Chairwoman Bonamici, Ranking Member Klein, Chairman Scott, Ranking Member Fox, and other members of the subcommittee. I'm Fatima Goss-Graves, President and CEO of the National Women's Law Center. Founded the same year that Title IX was passed, the Law Center has worked to remove barriers for women and girls in education, childcare, income security, the workplace, and healthcare for nearly 5 decades, and I very much appreciate the opportunity to testify today. My testimony will begin with the administration's new Title IX rule that went into effect last month, which the National Women's Law Center has challenged in court. The rule comes as harassment in school remains alarmingly high, including 56% of girls and 40% of boys in K-12 schools who report experiencing harassment. And as a 2019 report found, about 1 in 4 women and 1 in 15 men in college experience sexual assault. And LGBTQ students, students of color, and students with disabilities experience sexual violence at higher rates than other students. The student survivors we hear from at the Law Center recount what happens when schools don't meet their Title IX obligations. They've struggled to stay in school and have been expelled for lower grades. They've been suspended after being blamed for their assault. They've been discouraged from reporting and met with unfair skepticism. We've heard about schools that have had processes that have treated survivors unfairly, and in some cases they endured those traumatic processes with no outcomes that improve their situations. And this new Title IX rule puts students in schools in a terrible position. Under this rule, schools are required to dismiss many types of Title IX complaints, but no school should be even allowed, much less required, to dismiss a complaint simply because the student was raped at an off-campus party, or because each incident of the harassment they endured for months isn't considered severe by itself, or because a student dropped out of school when it was hard to be in the same class as their assailant. Nor should schools be allowed to ignore complaints because the respondent graduated or because a student reported it to a coach rather than to the dean. And it's simply unfair to require schools to have hostile grievance procedures only for sexual harassment complaints. This includes the new requirement that in higher education, any party and any witness submit to direct, live, and oral cross-examination. It's a reminder that these are not courtrooms and the rules of evidence don't apply. And that cross-examination could come from an angry parent or from a fraternity brother. No such requirements exist for addressing any other form of misconduct at schools, including other forms of discrimination or even a fist fight among students. This is a rule that sends a giant message that survivors are uniquely unreliable. And implicit in such a requirement is a deep-rooted skepticism of sexual assault itself. The department may claim that the rule will restore confidence in school proceedings, but the rule will prohibit schools from considering a broad swath of relevant evidence, broader than in courtrooms or in any other type of administrative hearing. It may claim that the rule helps survivors, but survivors have been fighting so hard these last 3 years to stop this very rule. And let me be clear, the survivors we work with are deeply invested in due process. They want to be treated fairly in these proceedings, and that is what fair process is about. And the outcome of this rule is that schools will be less safe. The other area I wish to highlight is this administration's attack on transgender students. Indeed, one of Secretary Devos' first official actions was to rescind key civil rights guidance on protecting transgender students from discrimination under Title IX. It's now been 3 months since the Supreme Court decided the Bostock decision. And in that case, the Supreme Court clear that Title VII of the Civil Rights Act ban on sex discrimination prohibits discrimination based on sexual orientation and gender identity. Following that historic decision, federal courts again have confirmed that transgender students are protected under Title IX. Yet in recent Title IX enforcement letters, the department attempted to limit the reasoning in Bostock to exclude transgender students from civil rights protections. It actually took the extraordinary step of threatening to take away federal funding from entities that refused to exclude transgender students from participating in sports. This extra step to argue that policies that protect trans students from discrimination are a Title IX violation is such a dangerous distortion of law and of precedent. In sum, the last 3.5 years, we have witnessed this administration turn Title IX on its head, and we believe students in this country deserve better. Thank you for the opportunity to be here today, and I look forward to any questions.
Thank you again to all of our witnesses. And under Committee Rule 8A, we will now question witnesses under the 5-minute rule. I'll be recognizing subcommittee members in seniority order, and to ensure that the members' 5-minute rule is adhered to, staff will be keeping track of time and will use the lovely chime to signal when 1 minute is left and when time is up entirely. The short chime will chime when there is 1 minute, and the longer chime when time is up, so please be attentive to the time. Again, if a member experiences technical difficulties, please stay connected on the platform, make sure you're muted, and immediately call the committee's IT director, Sheila Heavener, whose number has been provided. And I'm going to start by recognizing the chairman of the full committee, Mr. Scott. You're recognized for 5 minutes for your questions.
Thank you. Thank you, Madam Chair, and thank you for your courtesy of allowing me to go first. First, I would like unanimous consent to enter into the record a statement from Americans United for Separation of Church and State.
Without objection.
Thank you. Ms. Fry, it used to, one of the things that concerns me about discrimination with this administration is it used to be the weight of the federal government would be on the side of the victim of discrimination. That used to be the person trying to get a job or trying to eat at a restaurant. But now, apparently, if you look at the Office of Federal Contract Compliance Programs, OFCCP, they have a regulation that would bring the weight of the federal government on the side of federal contractors who want to discriminate because of certain religious beliefs, so that not the person seeking a job would have the weight of the government protecting them, but the employer who wants to discriminate would have the weight of the federal government protecting that right to discriminate. And that violates 80 years of precedence when President Roosevelt signed Executive Order 8802 to eradicate race discrimination in federal contracts. Can you say what you, the difference between the weight of the federal government being on the victim of discrimination rather than protecting the right to discriminate?
Well, thank you for the question, Mr. Chairman. And you're absolutely right. I mean, the Executive Order 11246 that was signed by President Johnson really came out of a legacy of recognizing that the federal government really had a critical role to play in ensuring that access to employment was open for everybody. And when you look at that history from Roosevelt, Eisenhower, Truman, Kennedy, you know, across Republican and Democratic presidents, they have used the power of the federal government to ensure that all workers, Black, white, all races and ethnicities, and expanded to encompass other demographic groups, really were available, particularly with employers who are getting federal dollars. And, you know, I think that's the important piece here, is that the federal government has a role generally to enforce civil rights laws, but particularly when you're talking about employers, contractors who have been given significant sums of money to do the work of the federal government. There, the government has a higher obligation to make sure that the workplace is open to everybody and it's free of discrimination. And that's really the legacy that the OFCCP should be standing behind.
Thank you. And I'd ask unanimous consent that my letter of December 20th, 2019 to Secretary Scalia on OFCCP's proposed rule to allow federal contractors to broadly discriminate against employees be entered into the record.
Without objection.
Thank you. Ms. Goss-Graves, the Department of Education's final rule in Title IX removes the advance notice requirement that religious schools that are going to claim sex discrimination protections conflict with their religious tenets no longer have to provide advance notice about which part of Title IX they claim to be exempt from. The final rule also allows the school to withhold that information until a discrimination claim is filed against it. Can you address how this policy will harm students?
Thank you, Mr. Chairman. I think that this policy will harm students because both the Department of Education, but it's actually the own students will not know, and it will encourage post justifications for the discrimination that they engage in. So students will be at the schools attending, not understanding that they may be receiving discrimination at some point, but schools have incentives to make up reasons after the fact to justify discriminatory conduct.
Thank you. Madam Chair, by the time I get another question, my time will expire, so I'll yield back. And thank you very much for your courtesy.
Thank you, Mr. Chairman. Next, I recognize the ranking member of the full committee, Ms. Fox from North Carolina, for 5 minutes for your questions.
Thank you, Madam Chairman. I appreciate that. Ms. Harris, I've long been concerned with the expectation placed on educational institutions to investigate and adjudicate violent crimes at all. Allegations of sexual assault should be investigated and adjudicated solely by the criminal justice system. Even the best campus adjudication processes are staffed by people who do not have the professional expertise to properly handle such cases. In your written statement, you applaud the department's regulation for returning the application of Title IX in these cases to its proper place. You observe the purpose of Title IX has historically been and should currently be the preservation of educational access for victims of discrimination. Unfortunately, the Obama administration and I guess my Democrat colleagues have embraced an alternative view of Title IX you articulate in your written statement, where its purpose is to provide a second avenue for punishing criminals. Could you explain further how the Trump administration's regulation properly refocuses Title IX on protecting the educational access and turns us away from the Obama administration's insistence on turning Title IX into a quasi-criminal statute?
Yes, thank you, Chairwoman Fox. I believe that, through a series of court decisions, dating back 20 or 30 years, sexual harassment, including sexual assault, are considered forms of sex discrimination that schools have to address under Title IX. So Title IX does require schools to have mechanisms in place for adjudicating these cases. And I think that by adopting important due process protections, this new rule ensures that those proceedings will be fair and will reflect, as you say, the quasi-criminal nature of the allegations and the seriousness of the allegations. But I also think that by the focus on supportive measures and by other features such as the availability of informal resolution and the scope of jurisdiction that the court set forth in the Devos case, it does restore also the focus, as you say, to the access to education, because that is really what this is about. I mean, Title IX is not an all-purpose law prohibiting all sexual misconduct. We have laws prohibiting sexual misconduct, and whether those laws are properly enforced or whether more needs to be done to enforce those laws fairly for the benefit of survivors is a different discussion. But Title IX is a limited jurisdiction law that relates to educational access. And so I think that by, defining it, defining both the definition of harassment and the scope of jurisdiction in accordance with the court's decision in Devos, and by focusing on the supportive measures that will allow a complainant, whether or not he or she brings a formal complaint, to continue to have that educational access, this new regulation does, as you say, restore that focus.
Thank you. Ms. Harris, some critics of the regulation have argued that vigorous due process protections and clear standards are unnecessary and even inappropriate in campus judicial proceedings because the stakes are lower than they are in a legal proceeding. It's really foreign to me how they can feel that way. Do you agree the stakes in campus judicial proceedings are such that campuses can dispense with our country's traditional understandings of basic fairness, clarity, and objectivity? Why or why not?
No, I don't. I mean, it isn't a criminal court, and no one has argued that a campus judicial system needs to have all of the protections of a criminal court. But as numerous federal and state courts have recognized, finding someone responsible for sexual misconduct, even on campus, has serious and life-altering effects, as it should if the person is responsible for sexual misconduct, as it should. But that is why we need full and fair procedures to determine whether someone is actually responsible, because, not failing to recognize that the stigma of being, labeled a sex offender, even on campus, has those serious and lifelong consequences. And I could tell you stories, but I have 30 seconds of some of those consequences. It fails to take into account the seriousness of the allegation. And I think, providing these protections, which again are not commensurate with those found in a criminal court, but which are higher than would be found for, say a plagiarism allegation, reflects the fact that schools are by necessity adjudicating what really are quasi-criminal allegations. Thank you.
Well, thank you very much. Thank you, Madam Chairman. I yield back.
Thank you, Ms. Fox. And I will now recognize myself for 5 minutes. Ms. Fry, in response to the Bostock decision, your testimony is urging the administration to take immediate steps to ensure that its policy positions are in line with the court's ruling, including reversing course on its ongoing efforts to deny protections to LGBTQI plus individuals. Will you please elaborate on the policy areas that need to be modified in light of the court's ruling?
Yes, absolutely. And I think I, along with the co-panelists, spoke to a number of them. I think, certainly you start with the memo that was in guidance issued by DOJ to U.S. attorneys across the country seeking to just take a different position in Title VII cases. That has now been countered by the Supreme Court. But there are many areas in education, in housing, in terms of access to things like domestic violence shelters, in healthcare, and certainly in employment, a number of areas where the administration continues to pursue rules and guidance that would limit the access of protections to LGBTQ workers and also folks in religious institutions or educational institutions and other areas. So I think it's a moment for that to be a full stop. And to issue across the board to all of the agencies and that they must comply with Bostock, and they must also comply with the spirit of Bostock. I think that's the first start.
Thank you so much. Ms. Booker, just days after Bostock was decided, as we heard in testimony, the Department of Health and Human Services finalized its Section 1557 rule, rolling back non-discrimination protections. And then within a matter of weeks, 2 federal courts had enjoined portions of the rule, relying heavily on Bostock. Specifically, the case decided on September 2nd in the DC Circuit, Judge Boasberg highlighted in his opinion that the rule was finalized even without pausing to consider the court's decision. The department's 89-page final rule did not even acknowledge Bostock's holding. So will you please explain how the rule is inconsistent with Bostock? And then
yeah, absolutely. Sure. The rule is, well, the court enjoined it because they found it was arbitrary and capricious to not even mention the Bostock or grapple with the decision in any way. But it's inconsistent with federal law. This isn't, Bostock, is a culmination of a lot of work that's been done for over 20 years to establish protections for LGBT, to clarify that LGBTQ people have protections under a variety of federal laws, including Title VII and Title IX, the Equal Credit Opportunity Act, and other statutes. And HHS conceded itself, I guess before they knew the decision was going to come out the way they didn't expect it to, that Title VII and Title IX are read consistently. And people probably know this, but Title IX is one of the 4 statutes that underlies the non-discrimination provision of the Section 1557. And they should be, and even actually acknowledge that Title VII should inform Title IX, but went ahead and issued the decision anyway. And we've seen already decisions that have been issued since the Bostock decision addressing, the question of whether and how Bostock would apply. And aside from the injunctions that have been issued in the DC case and the New York case, clarifying that they should have grappled with it, they've had decisions on the merits of Title IX with the additional threshold of addressing the question of whether it applies to sex-segregated spaces. And in a case that Lambda Legal brought in the 11th Circuit, the 11th Circuit held that it's discrimination under Title IX to prohibit a transgender boy from using the boys' restroom, and they cited Bostock using the same reasoning. Similarly, in the 4th Circuit, a decision was recently issued with the same reasoning.
And I'm going to put this question out there, but I might need to get your response in writing. So according to a study last year by the Center for American Progress, in this administration, the Department of Education's Office for Civil Rights was more than 9 times less likely to take corrective action on sexual orientation and gender identity related complaints than under the Obama administration. They're investigating fewer sexual orientation and gender identity related complaints, even though the overall number of complaints has increased. So after this report, I led a letter with several of my colleagues to OCR demanding information about their policies for processing sexual orientation and gender identity related complaints. Unfortunately, but not surprisingly, the response I received was inadequate. It left many of our original questions unanswered and necessitated follow-up. So without even seeing the requested documentation, we know that this administration has repeatedly failed to protect the rights of LGBTQ students. So I'm going to ask you to submit for the record your response to that question about what should the administration be doing to protect LGBTQ students. So because my time is up, I'll ask you to submit that for the record, and without objection, I would like to enter the following statement and reports into the record. a letter from Representative Raskin and myself to Secretary Devos, urging her not to finalize the Uniform Administrative Requirements Rule, which would expand religious discrimination against students in higher ed, an open letter from education civil rights leaders regarding civil rights of LGBTQ students in light of the Bostock decision, a statement from the U.S. Commission on Civil Rights calling on the Trump administration to revise their regulations and enforcement practices to comply with Bostock, and finally, a letter from the Gay, Lesbian, Straight Education Network expressing concern about the Education Department's ongoing attacks on LGBTQ students. I'm submitting those for the record without objection. And next, I'm going to recognize, I believe, Mr. Johnson. Is that correct, or Mr. Klein? Mr. Johnson?
Mr. Johnson, please.
Mr. Johnson, you're recognized for 5 minutes for your questions.
Very good. Thank you, Madam Chair. My questions are for Ms. Harris. And I'm going to pick up where Dr. Fox left off, talking about this traditional basket of protections that participants in American adjudicatory settings so often have. And I'll start with the discussion about this live hearing. That has undergone some criticism with concerns that maybe the potential victim, the complainant, could be subject to intimidation or harassment. You addressed some of this in your written testimony, I believe, but talk to us a bit. Do you think the rules by the Department of Education struck the right balance in protecting complainants while ensuring fairness in the process?
I do think so, yes. And, I think that the due process protections, while we often talk about due process protections in terms of what they do for the accused, what they also do is protect the integrity of the process as a whole. And, in cases that turn on credibility, the opportunity to have a hearing, to have the decision makers hear from both parties in person and have both parties answer questions in real time, that accrues to the benefit of both parties. I mean, there's no question that when you're dealing with a sensitive topic like sexual assault, any kind of proceeding is going to be difficult. And no matter how, and any kind of proceeding could be conducted with or without sensitivity. An investigation only could be conducted in a sensitive or insensitive way. A hearing with cross-examination could be conducted in a sensitive or insensitive way. And I believe that it's incumbent upon every institution, however they are conducting these things, to conduct them in a sensitive way, but that can't mean compromising fundamental fairness. And, courts have begun to consider what due process means in this context. Prior to 2011, that law had not been super well fleshed out. We knew that public university students in facing suspension or expulsion were entitled to due process. But what that meant, what that means is relatively case specific and has to be fleshed out sort of incrementally. And in the past years, it has been fleshed out a lot. And what an increasing number of courts have held is that in this context, when credibility is at stake, a live hearing with some sort of opportunity for cross-examination is in fact a critical element of due process.
Well, and Ms. Harris, that makes sense to me. And in a past life, I was a fact finder, a public utilities commissioner, and I want to make it clear I'm not in any way comparing that kind of contested case environment to one where sexual harassment is at the heart. I mean, I can't imagine the trauma that a victim experiences. But it does seem to me when you talk about serving the process and making sure that the right facts come to light, as a fact finder, I routinely would note that I think the process was better served in a real-time examination of the facts, and that all parties, I think, were better able to help the fact finder identify and illuminate these key issues. So what you're saying makes sense to me. So, and we have talked about protections for due process as relates to the accused, but there are also some additional protections, as I understand it, for the complainant. Could you talk a little bit about those?
Well, sure. So one protection relates to the use of medical records and provides that medical records can't be used in a proceeding without a party's explicit consent. And there are times, I mean, there have been cases where medical records might be central to a case. Questions evolved about, how a medication might have interacted, for example, with alcohol in a way that the other party may not have been able to recognize. And so, this is something that could, in some ways, harm the fact-finding process because the medical information may be relevant. But the regulations provide that, without a party's consent, that type of sensitive medical information can't be disclosed. I truly believe that the option for informal resolution, which was something that the previous administration had precluded in cases involving any physical misconduct, I truly believe that, so long as universities, follow the regulations instruction that they may only be used with the consent of both parties, without any type of coercion, that gives control back to victims, who may not want themselves to go through a whole full process, but who may want some sort of reckoning or accounting for what has happened.
Thanks, Ms. Harris. Thanks, Madam Chairman, and I yield back.
Thank you, Mr. Johnson. Next, I recognize Mr. Grijalva. Is Mr. Grijalva with us? I don't believe so. Ms. Fudge? Nope. Dr. Schreier. It's hard visually because I don't see Dr. Schreier. Okay, I know Ms. Hayes is here. I recognize Ms. Hayes for 5 minutes for your questions.
Thank you, Chairwoman Bonamici. Can you hear me?
Yes, we can hear you.
Okay, thank you. And thank you to all of the witnesses who are here today. As has been mentioned by this committee, Connecticut is currently fighting to protect our students from the Department of Education with the express purpose of protecting, uplifting, and educating all students. Despite the Supreme Court's hearing that federal civil rights laws prohibiting discrimination on the basis of sex protects transgender individuals, this Department of Education is threatening to withhold and redirect millions of dollars in Magnet School Assistance Program funds because Connecticut school districts are abiding by a state policy of the CIAC to allow transgender youth to participate in accordance with their gender identity. This is congruent to the Supreme Court's June opinion in Bostick versus Clayton County. These grants are specifically designed to assist in desegregation, promotion of diversity, and equitable education for all students in public schools. This is particularly devastating in Connecticut, which remains one of the most educationally segregated states in the country. Before I ask, I just want to say, there's a whole lot about the journey of transgender youth that I don't understand. I don't understand, gender identity and expression and how it presents itself at different ages. But what I do understand is discrimination and the fact that these are somebody's children, and it is our job to protect these children. And federal funding should not be contingent upon that protection. So my question for you, Ms. Graves, as an educator, I came to this committee from the classroom, and I can only imagine what teachers are dealing with as they have to uphold and defend some of these decisions. Ms. Graves, last week, OCR refused to recognize that the Bostick decision has any bearing on Title IX and the rights of students. Can you provide some context for what legal ground, if any, this administration can rely on to support such a decision?
I just want to begin by saying I also am deeply worried about our youngest students and the message that this administration is sending to them, and that some of their schools in turn will send to them. It's been 3 months since we had the decision in Bostock, and in that time, we've already had a Fourth Circuit decision be clear that that ban on sex discrimination includes gender identity discrimination. So what you would expect the Department of Education to be doing, and frankly, we have joined with members of the civil rights community after the Department of Justice to do this across the board, is to be clear that the Bostock decision application in terms of the meaning against sex discrimination has important consequences for education, but also for housing and for healthcare. Unfortunately, the Department of Education is doing the opposite. It is not only not clarifying that that ban on sex discrimination includes gender identity and that transgender students are protecting, it is taking this extraordinary step of continuing to go after these entities in Connecticut for having inclusive policies for transgender students. So it is an outrage and totally turning Title IX on its head.
Thank you. As you mentioned, I am deeply worried about this enforcement decision, and I know that what Connecticut is experiencing will ripple out into the rest of the country. And the fact that federal funds are now being contingent upon allowing students to participate or not to participate is concerning for me, to say the least. And I think it is a precursor to what we can expect. I don't think any child or any parent would open themselves up to this type of scrutiny for a sports medal, to say the least. Can you just provide just some context? Has this idea of the immediate revocation of funding been, I feel like Connecticut is being attacked disproportionately. Have similar cases been decided in the same way?
I have to be really clear on this point. It is a highly unusual step to actually take measures to remove federal funds, in part because the department has so many other tools to use that you don't see it. But so to have this very rare, and there may have been one other example over the last 50 years where this has happened, it is unusual.
Thank you. Madam Chair, I yield back.
Thank you, Ms. Hayes. Next, I recognize Ranking Member Klein for 5 minutes for your questions.
Thank you, Madam Chair. Ms. Harris, as you noted, there's been a lot of criticism leveled at the department for how it chose to define sexual harassment under the regulations. But in your written statement, you noted that the Supreme Court opinion that established that definition was authored by Justice Sandra Day O'Connor and joined by Justices Ginsburg, Souter, Stevens, and Breyer. Most have not read that opinion. Could you explain a little bit more about the court's rationale for establishing that standard and why that standard is still appropriate?
Yeah, thank you. So in the Davis decision, the court had to balance schools' obligation to prevent harassment with schools' obligation to uphold, particularly in the public school setting, the First Amendment rights of students. And it also had to recognize, the opinion explicitly recognizes that, school, particularly in the K-12 setting, is a place where students are learning how to interact with one another and are going to, insult and offend one another, and that you can't, to have a functional, system, it can't be that every act of name calling among children in school rises to the level of harassment. So when the court, crafted this severe, pervasive, and objectively offensive standard, what they were really focused on is access to education. It's not just a question of, has something happened that has hurt or offended someone on the basis of sex? It's, has someone's access to education been limited or denied on the basis of sex? And that's really where that standard comes from. And, it is interesting, as you note, that the majority opinion was authored by Justice O'Connor and joined by the court's liberal majority. And Justice Kennedy actually wrote a really strong dissent in which he expressed concerns, that even the Davis standard was insufficiently protective of free speech and was going to sort of open the floodgates. So in a way, it's ironic that the Davis decision has come to be seen as this, sort of extreme definition, when really at the time that it was crafted, it was viewed as the appropriate balance between the need to prevent harassment in schools and ensure that educational access is not denied on the basis of sex or based on sex discrimination, with the need to, protect free speech and to allow students, to learn sort of the rules of engagement, so to speak, particularly in the K-12 context.
Mm-hmm. Mm-hmm. You also addressed the criticisms leveled at the jurisdictional limits to campus adjudication of sexual harassment allegations under the regulation. And you point out that the Supreme Court said that an institution's liability under Title IX is dependent on the degree of the institution's control over both the harasser and the environment in which the harassment occurs. In other words, a school becomes liable or potentially liable when it exercises some control over both the accused and the location where the harassment occurs. Could you discuss in more detail how the Trump administration's regulation strikes that balance and why that is a better approach than the previous administration's guidance?
Yeah, I mean, so it's interesting in the Davis decision, although the decision, as you say, related to liability, when talking about the jurisdictional limitation, the court actually referred to the language of Title IX itself, of the statute itself, and said that the statute, by its plain language, cabins the range of misconduct that can be addressed. Because again, we have laws in this country prohibiting sexual misconduct. If a student commits sexual misconduct or commits rape off campus, that student has violated the law. Now, again, it's a whole separate conversation about how those laws are enforced and whether they are being well enforced. But Title IX is a statute about educational access. And as such, the court held that the plain language of the statute requires this nexus to the institution, such that the institution, as you say, exercises control both over the harasser and over the environment in which the harassment occurs. And in this instance, the administration is really just going back to what the court said about the statute's plain language. I would argue that it's not really in the department's authority to do anything else.
Thank you. And in the little time I have left, you noted that it was the last administration that departed from the Supreme Court's precedent and longstanding department guidance on the definition of sexual harassment, and that the Obama administration's definition was extraordinarily broad and at odds with the First Amendment. Can you explain a little more about why you would say that?
Well, yes, any unwelcome conduct of a sexual nature, including verbal conduct, which was the definition, includes in addition to actual harassment, a lot of speech protected by the First Amendment.
Thank you. I yield back.
Thank you, Ranking Member Klein. And next I recognize Representative Trone for 5 minutes for your questions.
Okay, thank you very much, Madam Chairman, for holding this hearing. Let's start with Mrs. Fry. EEOC recently issued a proposed rule to increase employer participation and conciliation efforts. In your view, does this strengthen, weaken EEOC's enforcement authorities? Who are the winners and losers in this rulemaking?
Well, it's a great question. There is some history behind this rule and this rulemaking. And part of that history is that while it's important for conciliation to happen and to be able to try to resolve complaints before they go to litigation, the rules previously, many employers were trying to essentially delay the ability of the EEOC to actually move forward with the case. And they would argue that they hadn't actually done all the steps for conciliation. And this issue was litigated in the Supreme Court, and the Supreme Court said in a decision, Mock Mining versus EEOC, that the EEOC was not bound by a specific rubric that was required to conciliate, and that the rules were much more deferential to what the EEOC, as long as they were operating in good faith. And so the concern here is that this rulemaking could resurrect this notion that there has to be a specific set of procedures that the EEOC goes through in order to be able to litigate. And it's really a delay tactic that ultimately hurts litigants and particularly workers who are in need of protection. That's the concern.
Exactly. Let's jump, Ms. Fry, to salary transparency. It's an interesting area. Can you help us to identify, looking at where barriers exist, and at the same time, we don't want to eliminate merit at the same time. So your testimony discussed the model in the United Kingdom, requiring large employers 250 or up to publicly disclose gender pay gaps. Can you explain how this system would work, and you think it could be successfully adopted in the U.S.? And how would you see it implemented here, but still not to take away merit?
Well, absolutely. I think, what we've learned in the UK is that for employers with 250 or more employees, they're now required to report their pay gap, and they actually do it by, I think it's quartiles. And it's a way of giving other people better information, employees themselves, so they can make good decisions. And it also incentivizes employers perhaps to look closely at their practices and take corrective measures. And I do think we ought to be thinking about whether or not a rubric like that would work here, and to complement enforcement that's already being done and the work that employers do on their own to look at their pay practices. And it could be a legislative measure that Congress pursues or something collaborative with the department. But I definitely think it's worth looking at.
Okay, great. One of the provisions of the Fair Play and Safe Workplace Executive Order, which Trump rescinded, prohibited contractors from requiring employees to sign, pre-dispute arbitration agreements for discrimination claims and torts for sexual harassment and assault. Again, who are the winners and losers in this one?
Well, the purpose of that is, more than 60 million workers are covered by arbitration agreements. And what that does is that limits their ability to vindicate their rights under the laws that many of us are familiar with, like Title VII. And so the Fair Pay and Safe Workplaces Executive Order was really designed to limit the situations where that occurs, so that workers who are, already in a challenging situation in terms of bringing cases are not unfairly hindered in their ability to vindicate their rights under the law. That's why that provision was so important, and it basically said that you can't require people before a dispute arises to say that they're going to take their case somewhere else.
And so once again, our workers got the short end of the stick.
Yes, sir.
Thank you, ma'am. I yield back.
Thank you, Mr. Trone. Mr. Klein, do you have other members present? Mr. Thompson, perhaps?
It does not appear that Mr. Thompson is here, so.
I recognize Ms. Lee for 5 minutes for your questions.
Thank you, Madam Chair, and thanks to all of our witnesses for joining us today to discuss these very important issues. First, I want to acknowledge that there's been a lot of jargon, legal jargon, and acronyms thrown around today, but to be frank, quite honestly, we're speaking about one plain and simple principle, and that's equality. We've heard today about many ways in which Secretary Devos and this administration have worked to weaken, roll back, remove any key civil rights protections, particularly for LGBTQ individuals and women. And as someone who has spent my career working among our most vulnerable populations in Nevada's public schools, I'd like to first focus on how these actions are hurting students, particularly students that are at high risk of falling behind or dropping out, or even worse. To Ms. Goss-Graves, as we discussed today, in 2017, Betsy DeVos rescinded key guidance that secured the rights of transgender students, leaving transgender students now more vulnerable to ongoing discrimination at school. Can you speak to how this rescission of the guidance does just that?
Well, the first thing to know is that transgender students are more likely to experience discrimination and harassment in school, and study after study has shown that. And that the harassment that they experience, that when they do go forward, they are less likely to be believed or told to change who they are, rather than having the schools enforce their rules. So we are already starting out at a place that's worrisome. But the combination of the message that the Department of Education is sending, that they don't really have to do what they need to do with the Bostock decision, plus the change in the Title IX sexual harassment and violence rules, could have devastating effects, especially for all LGBTQ students, but transgender students in particular.
Thank you. I'd also like to break down the Bostock Supreme Court decision that we've heard a lot about today, and how that decision contrasts with this administration's policies regarding gender discrimination. As you all know, this past June, the Supreme Court confirmed that the Civil Rights Act protects transgender workers from discrimination because of sex, much in the same way that Title IX has been interpreted to protect transgender students. One would logically conclude that this decision settles the matter regarding the inclusion of gay and transgender individuals protected under anti-discrimination laws that afford protections based upon sex. And this decision is in a stark contrast to the administration's position that Title VII of the Civil Rights Act does not protect discrimination based on against sexual preference and gender identity. Ms. Fry, in response to the Bostock decision, you've urged this administration to, quote, take immediate steps to ensure that its policy positions are aligned with the court's ruling, including reversing course on its ongoing efforts to deny protections to LGBTQI+ individuals. What are some of the policy areas that need to be modified in light of the court's rulings?
Well, I think, where we start is making sure that the administration is clear across all the agencies that the Bostock decision does indeed say that sex discrimination should be read broadly to encompass the rights of LGBTQI workers. And really that then sends the message that from education to housing to employment, all of these areas that they continue to push these types of rules, they need to fundamentally reverse course. It also means litigation. We didn't mention that they continue to intervene in cases where they have advanced arguments that now the court has said are not valid. So I think it is really a full stop on all of these efforts, and to make clear that across the board, they need to rethink how they are interpreting sex discrimination.
Thank you so much. And again, I just want to make sure that we continue to focus that the key issue here is not lost in the legal jargon. Simply put, this is about equality for every student, worker, parent, and child. And so thank you, Chairwoman, for having this important conversation and all the witnesses, and I yield.
Thank you, Ms. Lee. And I believe we are, is there any other member present who's not on the subcommittee? It appears not. Well, I want to remind my colleagues that pursuant to committee practice, materials for submission to the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing. So by close of business on September 24th, 2020, preferably in Microsoft Word format. I do know there will be some additional questions for the record, including asking for a follow-up on the interpretation of the Devos case. I know that one will be coming, as well as others. The materials submitted must address the subject matter of the hearing. Only a member of the subcommittee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated in the record via an internet link that you must provide to the committee clerk within the required time frame, but please recognize that years from now, the link may no longer work. Pursuant to House Resolution 965 and accompanying regulations, items for the record should be submitted electronically by emailing submissions to edandlabor.hearings@mail.house.gov. Member offices are encouraged to submit materials to the inbox before the hearing or during the hearing. At the time the member makes a request, the record will remain open for 14 days per committee practice for additional submissions. So again, I want to thank the witnesses for their participation today. It's been very informative. Members of the subcommittee may have additional questions for you. I noted that there will be some, particularly about the Devos interpretation. We ask the witnesses, please respond to these questions in writing. The hearing record will be held open for 14 days to receive those responses. And I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. Now, I recognize the distinguished ranking member, Mr. Klein, for his closing statement.
Thank you, Madam Chair. I appreciate you calling this hearing. I want to thank the witnesses for offering their expertise today. I do want to reiterate that this is a wide-ranging hearing, and it's unfortunate we only had one witness to cover such a broad. She ably covered all the topics, but I would have liked to have had a little bit more opportunity to have more witnesses. On the issue of the department's regulation with respect to how schools adjudicate sexual harassment claims under Title IX, I want to reiterate just a few points. First, on a really sensitive and potentially divisive issue, it's noteworthy that individuals across the spectrum have supported the Trump administration's actions, and that's pretty unprecedented in the current climate. And second, I want to highlight the earlier discussion between the ranking member Fox and Ms. Harris. It seems the core of the disagreement is a difference of opinion on the purpose of Title IX. Nobody's arguing that perpetrators of sexual violence should not be punished. I'm a former prosecutor and understand that criminals should be punished to the full extent of the law. But Title IX exists to protect students' access to the educational environment, and I applaud the Trump administration for restoring the purpose of Title IX through this regulation. It offers clarity based on court precedent and protects the rights of students. It protects the rights of respondents. Yes, consistent with the emerging case law, but it also protects the rights of survivors, and that is critical. One thing we learned today is that survivors of sexual assault were poorly served by the last administration's mess of the Title IX in this space. I applaud the Trump administration for correcting those errors. Madam Chair, thanks again for holding this hearing. I'm honored to be a member of the subcommittee, and I look forward to working with you in the future, and I yield back.
Thank you, Ranking Member Klein. And I now recognize myself for the purpose of making my closing statement. I want to thank our witnesses for sharing your expertise throughout the hearing. Today, we examined the full scale and effects of the Trump administration's attacks on gender-based civil rights. We discussed, and it is a broad issue and a broad topic, but very important. We discussed how the administration has undermined protections for transgender students and sexual assault survivors. We reviewed how the administration has stripped civil rights protections from LGBTQ workers and halted our progress in addressing pay disparities based on gender, race, and ethnicity. We discussed how the president has attempted to eliminate patient protections for women and LGBTQ community in the middle of a global pandemic. These issues are not merely policy disputes. These civil rights protections are about preserving dignity and securing the inherent, unalienable rights of every American. When our government allows, and in fact even endorses, discrimination against certain individuals, it sends a message about their value in our society. It says you are not worthy of a quality education, a good paying job, or vital healthcare services because of who you are. That is unacceptable. We must be a nation where everyone, no matter what they look like, who they are, or who they love, can live free from discrimination. This principle has been the foundation of our nation's civil rights laws for decades. I look forward to working with members of this committee to repair the damage done over the last 4 years and to create a more inclusive nation that truly achieves liberty and justice for all. Thank you again to our witnesses for being here and to all the members who participated. If there is no further business, without objection, the subcommittee stands adjourned.